Hello, everyone, and welcome to week 4. This week's lecture is on poverty, crime, and juvenile justice. I have done a lot of research on juvenile crime, particularly answering the question of why youth commit crime to begin with. Before we get to that question, however, we will explore the history of juvenile justice in the United States and examine the approaches that courts take in juvenile cases. This is the picture in the beginning of the chapter of your textbook. What do you see? I see an ineffective way to communicate to a young person and a system that inherently views juveniles as adults. Keep in mind, there is a lot of research that suggests that youth cognitive and intellectual abilities are not fully developed until they reach adulthood, and hence their ability to comprehend and understand the consequences of their actions may indeed be limited. The juvenile courts of 100 years ago were not the same as they are today. Along with industrialization, the population of the nation almost doubled, growing from 40 million in 1870 to 76 million by 1900. Much of this growth resulted from immigration. The immigrant urban masses were associated with poverty, social disorder, and crime in the emerging big cities. Protecting society from the quote-unquote dangerous poor became a pressing social concern. During this time, children under the age of 7 were presumed to be incapable of criminal intent and were therefore exempt from prosecution. However, children 8 and over were considered adults in the eyes of the law, prosecuted as adults, convicted as adults, and served their sentences in the same prison cells as adults. Progressives wanted to save those who they viewed as the quote-unquote dangerous poor children. Their efforts to save children reflected a major shift in thinking about youth development and criminal justice. In particular, the fact that children have less than fully developed moral and cognitive capacities led to the adoption of the juvenile courts, which were separate facilities from those that house adult offenders. Today, many court reform advocates believe that the current juvenile justice system does not deal effectively with youth and the complex problems they face. They advocated rather for an approach where 1, children really aren't that bad, and 2, children are a product of their environment. Parens patriae is a Latin term meaning parent of the fatherland. In law, it is the power of the government through the courts to intervene on the behalf of individuals or groups of individuals who are unable to represent their own interests. This includes children and disabled adults who lack willing and able caregivers and often require the intervention of the courts through this doctrine. For example, if parents fail in their responsibility to raise a child properly, the state can intervene to protect that child's welfare. This doctrine also means that in extreme circumstances, parents' rights over their children could be terminated altogether. It is this doctrine that allows, for example, the government to take responsibility for the care of children who are unaccompanied and found at the United States-Mexico border. Parens patriae is a legal term referring to the power of the government to act on behalf of people who are unable to care for themselves. For example, the doctrine of parens patriae empowers a judge to assign or reassign custody of a minor child regardless of the parent's wishes. In practice, parens patriae is commonly understood to represent the interests of children, but this is clearly not always the case. The doctrine has at times also been applied more broadly to protect the well being of the entire population. As the doctrine of parens patriae emerged, attitudes about children began to shift simultaneously. No longer were children viewed as miniature adults, they began to be seen as having less developed moral and cognitive capacities. Juvenile courts differ from adult courts in a number of important ways. When it comes to juvenile matters, the standard applied is always the best interest of the child. This is oriented more towards helping children rather than punishing them. Note that what is in the best interest of the child will vary from case to case. Juvenile court cases are informal proceedings based on civil law, whereas adult cases are formal and based on criminal, not civil law. Juvenile proceedings are mostly secretive unless the juvenile is being tried as an adult. Adult proceedings are a matter of public record only. Finally, there is no jury trial in juvenile court. The judge decides both issues of fact and issues of law. The trial is not public and there is no bail granted. Here is an example of a rare case where a juvenile's name is released to the public. In this case, a 13-year-old and a 14-year-old boy have been arrested in the horrendous stabbing death of Tessa Majors, an 18-year-old freshman at Barnard College in New York. According to the prosecutor in this case, the law requires a 13-year-old charged with felony murder be prosecuted in family court and gives jurisdiction to the prosecutor's office where a 14-year-old is charged with intentional murder and felony murder. In this case, just last week, the 14-year-old, whose name is Rashawn Weaver, was taken into custody in connection with Major's death in Manhattan. Please look up this important case. As seen from this quote from a Denver juvenile court judge, the juvenile courts are about more than just law. They're about social work. They're about control and help. They are trying to be a good parent and also simultaneously a stern parent. They are both formal and informal. They are concerned not only with the delinquent, but also with the battered child, the runaway child, and many others. The juvenile court has been all things to all people. Historically, the focus of the juvenile courts has been to rehabilitate the juvenile offender. Recently, however, the focus has been on punishment more than rehabilitation. This is not in keeping with the focus of the courts on parens patriae and viewing juveniles as not similar to adults. As I just mentioned, the times have been changing and the juvenile courts are beginning to take more of a punishment approach. The theoretical purpose of the juvenile justice system has therefore shifted from rehabilitation to punishment during the last few decades. Even if their case does remain in the juvenile courts, juvenile offenders often face multi-year sentences. As well, for sexual offenses, juveniles are often required to register as sex offenders under Megan's Law. For example, a 15-year-old juvenile offender who makes unwelcome sexual advances toward another 15-year-old juvenile will have to register as a sex offender. Does this surprise you? The juvenile justice system structure and process is defined by the individual states. This website, which I encourage you to look at, describes the different approaches to understanding the purpose clauses which define the goals of juvenile justice in each state. The first is no clause. That is, these states have no juvenile court purpose clause at all. The second approach is called parens patriae, which in Latin again means father of the nation and applies to clauses that reflect the juvenile court judge's earliest role as the state's designated protector of children, particularly in situations in which their parent cannot protect them. The third approach is called the due process approach. This refers to the reform period of the 60s and 70s, where federal laws, statutory acts, and Supreme Court cases have influenced the addition of due process procedures in juvenile justice cases. These are things like the right to notice of an impending charge against you, the right to counsel, the confrontation and cross-examination of witnesses that will present evidence against you at trial, and the privilege against self-incrimination, none of which have historically been applied to criminal justice proceedings. But see later on a court case called N. Ray Galt. The fourth approach is called balanced and restorative justice. These states adopt a model of reform released in the early 1990s on the heel of the most punitive era of juvenile justice. And finally is the developmental approach. These states retain all of the elements of prior categories, but have purpose clauses that mention the use of adolescent development or other research or data to assist the juvenile justice system, requiring the use of evidence-based practice. That is, the practices that are most effective in dealing with youth and adolescents. Again, please take a look at the website to get a better idea of these various approaches. This is a picture of a map that I took from that website. For example, these 5 states take a developmental approach in their juvenile justice purpose clause: Florida, New Mexico, Idaho, Kentucky, and West Virginia. This means that these states should theoretically incorporate social science and criminal justice research, including incorporating ideas regarding why youth commit crimes and the best methods to prevent recidivism. By the end of this lecture, you will see that the courts purporting to take a developmental approach, in theory, really do not.